All right, buckle up, folks, because what you're about to witness is a legal showdown filled with tension, confusion, and some shocking choices that could change a man's future forever. This is the case of State versus Michael Wade, a defendant caught between probation, deferred adjudication, and the looming shadow of a felony conviction. The judge wastes no time making it crystal clear. One wrong move, and Wade could be staring down a decade behind bars. But here's where it gets complicated. Wade seems almost ready to accept the weight of a felony conviction, despite his attorney's efforts to steer him otherwise. Is this naivete, pressure, or just desperation to get it over with? Let's break this case wide open.
It's two cases, Your Honor, and the state has agreed to probation. Thank you.
All right. And Ms. Abrams, I'll take this, but then he can come back this afternoon for you to go over conditions. So you're going to need to come back this afternoon
Yes, ma'am. That's
To talk to her.
to talk to probation. I need to make sure everyone has their lunch break, okay?
That's fine. Yes, ma'am.
All right, the court is calling 2025 CR 004949 and 2025 CR 004950, State versus Gerard Michael Wade. Could I have parties announced?
Dr. Whitlock for the state of Texas, Your Honor.
James Seeloff for the defense.
Counsel, in each of the cause numbers, did you review the discovery with your attorney? I'm sorry, sir, did you review the discovery with your client?
With myself and my client.
And have you received all discovery?
Yes, I believe I did.
All right, in each cause number, the court will find that the state is in compliance with discovery. Mr. Wade, in each cause number, did you review the application for deferred adjudication with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
In each cause number, did you review the true bill of indictments with your attorney?
Yes.
Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, in each cause number, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Wade, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And for 9, you're charged with evading arrest, detention with a vehicle. And the cause number ending in 50, you're charged with assault on a public servant. Those are third-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. And by entering this plea, you are giving up those rights. Did you understand that? And did you intend to give up those rights? And did you understand that you are also giving up the right to remain silent? And did you intend to give up,
Louder.
and did you intend to give up that right? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison in each of these cause numbers and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I think he was.
Mr. Wade, in each of these cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
And each cause number, according to the plea bargain agreement, punishment is to be assessed.
Did you catch that? Even the paperwork from the state had a critical error. The wrong box checked on deferred adjudication. In real life, this isn't just a typo. It could be the difference between a clean record and a lifelong conviction. The judge calls it out, both attorneys agree it happens, and they move on. But for Wade, this isn't just a clerical mix-up. His entire future hinges on whether that box says deferred adjudication or not. Imagine your freedom, your career, your entire reputation hanging on a single check mark. Talk about pressure in the courtroom.
At 10 years in the prison, you're not a,
Probated for 6.
Well, no, it says that the box is checked that there is no application for deferred adjudication. And then it's the state is opposed to deferred adjudication. Sorry, sir?
The state is recommending community supervision, but the state is opposed to deferred. You're recommending
Okay.
probation. If the state checked the wrong box, I'm sorry.
And that's okay. Any objections to the court correcting the boxes?
None from the state.
No objection, Your Honor.
It happens. I don't know why they make it these so complicated. So
Too much.
the state is opposed to your application for deferred adjudication.
Yeah.
The state is recommending community supervision. The cases are to run concurrently. There's to be restitution to Stephen Enriquez. Did you understand that to be the plea?
Yes, ma'am.
Are you sure? All right, so let me explain it to you.
Yes, Your Honor.
Oh, that was the fee for the officer?
Yeah, that's going to be a hearing later on to
Okay, yes, ma'am.
determine his sprained finger.
Yes,
If it
ma'am.
costs anything.
All right, do you understand that?
Yes, ma'am.
All right, did you understand that to be the plea?
Yes, ma'am.
Do you understand the plea?
Yes, ma'am.
So according to the plea, the state is recommending community supervision, but they don't want you to have deferred adjudication. You understand that?
You understand?
All right, so community supervision is a form of probation,
Yes, ma'am.
but it's a felony conviction on your record. Deferred adjudication is a form of probation, but it is not a felony conviction on your record. Do you understand?
Yes, ma'am.
He really doesn't know.
Felony conviction. Do you understand?
Yes, ma'am.
All right. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That was our understanding.
State, is that the plea?
That is the plea, Judge.
And you do understand that I determine whether or not you receive deferred or not.
Yes,
You
ma'am.
understand that?
Yes,
Okay.
ma'am.
After hearing arguments from both parties.
Thank you. Yes, ma'am.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No motion.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There be 100 hours of community service restitution, defensive driving, and no contact with the complainant. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
That's our understanding. That's outside our plea agreement. Okay?
So in cause number 2025 CR 004949, how do you plead? Guilty, not guilty, or no contest?
Contest.
And in cause number 2025 CR 004950, how do you plead? Guilty, not guilty, or no contest?
Yes.
State any evidence to support the plea?
State authors State's Exhibit 1 with all attachments to both cases respectively.
No objection, Your Honor.
All right, in each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, so this is what I can do because the state is opposed to your application for deferred adjudication. I can reset this in a couple of weeks. You can bring whatever witnesses you want to bring. The state will give me his criminal history and we can go from there. And then I'll make a decision on whether or not deferred or,
Do you want to do that or do you want just probation from the bench today?
I'm not trying. I just want probation. I just want to get this over with, man.
well, let me just tell you. So here's the thing. People say they want to get things over with, right?
Yes, ma'am.
And they don't think about the consequences of their actions. What I'm telling you is your attorney has applied for deferred adjudication. Not getting this over with right now, maybe I'll give you deferred adjudication and you won't have a felony conviction. But if you want to get this over right now, then what's going to end up happening is you're going to have a felony conviction and that felony conviction is going to follow you wherever you go like a ball and chain. And it's going to affect your ability to get employment if that's what you're intending to do. But if you want to go for it, I'll go for it. You'll be found guilty and you'll receive your regular probation and it's going to be a conviction on your record.
Which way do you want to go?
How old are you?
31, ma'am.
31.
This is the heart of the case right here. Wade reveals he's a truck driver, meaning a felony conviction could destroy his livelihood. Employers run background checks, and with felon stamped across his record, his career could hit a dead end. His lawyer points this out, but even then, Wade still leans toward the faster option, probation with a conviction. Why? Because sometimes defendants are so overwhelmed, so exhausted by the system, they just want the ordeal to end, even if it means sacrificing their future. This moment highlights a brutal truth. Not every legal decision is rational. Some are purely emotional.
You don't need to look at your attorney to make a decision. Do you want to be a felon?
No, ma'am, I don't want, I'm a driver.
He's a truck driver, Your Honor, so it
Yes,
will
I know.
affect his livelihood down the road. However, I told him that it may or may not, who knows, 6 years down the road under this administration, we'll be truck drivers. But be that as it may, you have a choice today.
I just want to take probation, ma'am. I mean, that's what we,
Do you understand? We can go off the record. Do you understand what you're saying to me? You're saying to me that you want a felony conviction. And what I'm telling you is, according to your plea bargain agreement, if I give you a felony conviction and you mess up on it, you're looking at 10 years in the prison. If you end up with deferred adjudication, you don't have a felony conviction. And if you mess up on it, you're looking at 10 years prison. So you're telling the court that you want to take the easy way out and get a conviction on your record. So you can be the felon. Felon Wade. Is that what you want?
no, ma'am.
So why do you need to look at your attorney to make a determination on whether or not you want to come back in 2 weeks? Because maybe in 2 weeks, maybe I'll give you deferred adjudication. Maybe your attorney is going to present something to me that will tell me that you're deserving of deferred adjudication. Maybe the state is going to come back to me and say, this is the only thing he has. He doesn't have any other criminal history. So what do you want to do?
What should we do? Ma'am, I don't know the land of the law. I'm just here.
I'm going to help you out. We're coming back in 2 weeks.
Thank you.
Yes, ma'am. Thank you. So
All right. So in 2 weeks' time, Ms. Ferguson, give me a 2-week reset.
July 10th.
All right. So we're going to come back in July 10th. And at that time, the court will make a determination on your application.
Yes,
July 10th at 9 o'clock in this courtroom. Okay.
All right.
I'll give them a reset. Don't leave without the reset. Judge, is it going to be a tap as well?
No. You're waiving PSI, counsel?
I was going to.
All right. So the PSI is being waived.
It's waived.
For sentencing.
Yes.
Yeah.
thank you, ma'am.
You're welcome.
Thank you, Judge.
So here's where things land. Instead of letting Wade rush into a felony conviction, the judge resets the case for July 10th, giving him another chance to pursue deferred adjudication. This move could be life-changing. If Wade's attorney presents strong arguments, he could walk away without the permanent stain of a felony record. But if not, he's staring down the label of Felon Wade for good. This case is a prime example of how every choice in the courtroom carries massive weight, not just in the moment, but for the rest of someone's life. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your support helps us keep uncovering the drama, the strategy, and the life-altering stakes inside America's courtrooms.